Presenting our bills. So we are going to turn to SB 631, which is by Senator Noreen Evans, and I want to announce that in today's hearing on this bill will be strictly testimony. I will not recognize any motions on this matter today. Senator Evans has requested our staff to work with her and Commissioner Jones and all other interested parties the remainder of the year, keeping the bill on track as a 2-year measure. And I'm pleased to accommodate Senator Evans in this way, and now I would invite you, Senator, to open on your bill.
Well, thank you, Mr. Chair. And I think it is this is a very significant bill for the state of California. I think it's very important that we get it right. So we're very happy to put the time in working with you and the committee staff to make sure that we do exactly that. This bill would allow the insurance commissioner the express authority to order restitution to customers who have suffered financial loss because of violation of insurance law by insurers. And it is a very important authority that the insurance commissioner should have. 15 other states' insurance commissioners or similar constitutional positions in those states hold this same power, as well as other agencies within the state of California. So it's nothing unusual, but it is very, very important, I think, to the work of the Commissioner of Insurance and also for the protection of consumers in the state of California. And with that, I would like to turn things over to our Insurance Commissioner, Dave Jones.
Thank you. With the permission of the Chair. Thank you, Mr. Chair. It's a pleasure to be before you in this committee, and I want to thank Senator Evans, Chairperson Evans, for her leadership in authoring this important legislation, which, as she pointed out, provides the Commissioner with authority to order restitution only for the purpose of being able to make right a consumer's financial loss, out-of-pocket or economic losses due to insurers or insurance licensees' violation of insurance law. I do want to begin by noting that in the analysis, there was a suggestion that this bill, as currently drafted, may intrude upon certain reforms that were carried by Jackie Speier in the wake of the investigations and associated conduct by Commissioner Quackenbush. Both the author and I want to express to the Chair and the members of the committee that certainly was not our intention. In fact, we respectfully disagree with the suggestion in the analysis that our language intrudes there. But to make clear that there is no implication or suggestion that this legislation would intrude upon those sections of code that were put in place for purposes of the post-Quackenbush era reforms, with the permission of the author, we are pleased to propose an amendment. We've consulted with your chief counsel with regard to processing that amendment in due course while the bill is in this committee to remove that language, that notwithstanding language. Yes. We would like to reserve the right, however, to work with your committee to make clear that those Speier reforms, if you will, don't unnecessarily intrude on the ability of this bill to meet its core intention, which is to provide for restitution. But I did want to address that right up front because there was considerable time spent on that issue in the analysis, and that was the first opportunity we had to hear that was an issue. Just to the bill in chief, Mr. Chair, it is the case that insurance consumers occasionally suffer monetary loss due to insurers or insurance licensees' violation of law. Examples of these include an insured paying for out-of-pocket medical treatments that should have been covered under the health insurance policy, or a consumer being overcharged on a life insurance policy premium, or a senior that has been sold an inappropriate life insurance product. Right now, I have the legal authority to negotiate settlements around these sorts of violations of code that include restitution. And by restitution, this bill is very narrow. We're just talking about out-of-pocket expenses as well as economic damages. We're not talking about any other form of collateral damage. The anomaly is that while I have the current authority to negotiate settlements with restitution, I don't have the authority to actually order restitution as a part of a full-blown administrative enforcement action. And that's what this bill simply does. It tracks what other states have given their insurance regulators and insurance commissioners. It also tracks an authority that's been granted to numerous other agencies here in California. These agencies include the Department of Managed Health Care, the Commission of Corporations, the California Gambling Control Commission, the Public Utilities Commission, the Department of Fair Employment and Housing, and the Workers' Compensation Appeals Board. Now, I know there's a suggestion in the analysis that some of these agencies are constitutionally based and my agency is not. But some number of the agencies I just provided to you are not constitutionally based or statutorily based, and they nonetheless have restitution authority. One other issue that's raised in the analysis is an intrusion upon the separation of powers. In fact, the California courts have made clear that as relates to regulatory powers, separation of powers is not the critical constitutional issue. It's an issue called judicial check, and that is to make sure that there's some judicial check on the regulatory agency's authority. We have been very clear, the author and I, in drafting this bill, to ensure language, explicit language in the bill that provides for judicial review of the restitution order in order to meet that constitutional prerogative with regard to judicial check. In addition, this bill is consistent with Proposition 103, on which there is both statutory and case law where restitution is provided as a remedy there. So this is another anomaly. I have restitution as authority under 103, but I don't have it in other contexts. So this bill simply aligns us with other states, aligns us with the authority I have under Proposition 103, aligns us with the authority that other agencies have been granted by this legislature and by the Constitution, and gives consumers an opportunity to be provided with restitution when they've been injured as a result of a violation of law by an insured or a licensee. We appreciate the committee's consideration. We appreciate the opportunity to work closely, the author and I, with the committee as the committee considers the bill while it's in this committee. Thank you, Mr. Chair.
Thank you very much.
If I may
yes,
add
Senator.
one other thing. I have spent a significant period of time working with the insurance industry in identifying a lot of their concerns with the bill, including certain due process issues as well as other things, and we'll continue to work with them.
Excellent. Anyone else would like to testify in support?
Good afternoon, Chair and members. Ignacio Hernandez on behalf of the Consumer Watchdog. We're also in support of the bill, I think for the reasons already stated. We also wanted to point out that there potentially one possible issue in the analysis, and that is that, and of course, Consumer Watchdog is the author of Prop 103. And let me just pull up my notes, I apologize.
Sure.
That the way that Prop 103 works under Section 1858, it empowers the commissioner to take such other corrective action as he or she may deem necessary and proper in response to any kind of raid or violation. And so there really wasn't any limitation on the corrective action that could be taken. So we think that the analysis doesn't quite capture that, and I think that needs to be addressed going forward. And we can talk about that more later on separately, but I just want to make sure that we clarify that. I think that's an important point as we go forward.
Okay, thank you.
Thank you.
Yes, sir.
Mr. Chairman, Alan Wood. I represent the Collision Repair Association of California. We think this bill would add a great deal of clarity and provide the Commissioner with additional tools that he could use to assist consumers that have settlement issues during the claims process. And it would also provide an avenue outside the legal arena that they currently have to go through that is really cumbersome and actually, in some cases, prohibitive for them to try and get redress. So with that, we look forward to working further on the bill.
Very well, thank you.
Good afternoon, John Montevideo with Consumer Attorneys of California. I would like to echo this last individual's comments. This gives consumers an opportunity to be reimbursed for out-of-pocket expenses outside of litigation. It streamlines the system, yet tends to give them what they lost. We think in that regard, it's good.
Thank you.
David McClune with the California Auto Body Association, and we also echo the same support. We think it's good for the consumers. We'd like your consideration. Thank you.
Great, thank you. Anyone else wanting to testify in support? Please come forward. Having none, do we have anyone that wants to testify in opposition?
Good afternoon. Kimberly Dunn on behalf of the Personal Insurance Federation of California. We really just want to take this opportunity to thank the author and her staff, as well as the Department of Insurance staff. This is a bill we have serious concerns about, but they have been very generous with their time. We spent a lot of time talking about our concerns and are appreciative that they've taken that time, and we will look forward to working together over the next year to get it right, as the author said.
Thank you.
Sherry McHugh, representing the Pacific Association of Domestic Insurance Companies. I would like to echo Mrs. Dillinger's comments, and we look forward to working with the department and the author in the coming months to see if we can come to some type of resolution and compromise on the issue. In the meantime, I have with me today Bob Hogaboom, who is a insurance industry regulatory and disciplinary lawyer with Barger and Wolin, and we would like him to outline just a few of the specific concerns that we do have with the bill as currently in print. Thank you.
Great.
Thank you. I'm the senior regulatory lawyer at Barger & Wolin, and I customarily deal with disciplinary matters such as what the Commissioner has talked about today. I'm familiar with the bill, also familiar with the analysis of the bill. I think it was a good idea to put the bill over because I think it will allow a sufficient time to vet, I think, significant legal issues that are raised by the bill. And also, I think, to take additional time to look into what other states have done. We do not believe that other states grant this broad authority with regard to restitution to their commissioners. They may do it in significant or in certain parts of their insurance code, but not the broad brush that is suggested by the legislation. Further, again, the agencies that are mentioned do have quasi-judicial power, different from the Department of Insurance, which is, as you know, been around since the 1800s. The Insurance Department is essentially a licensing department. It licenses insurance companies and producers and regulates the solvency of insurance companies in order to protect consumers. They also have the ability, of course, to bring enforcement actions, but those are limited. They're limited in the code, and they're limited in the Constitution, the separation of powers in the Constitution, dealing with Article 6, Section 1, which Mr. Cooley does talk about in his analysis. So we do believe that the Commissioner's role with regard to enforcement actions is set such that restitution is a matter for the courts. 103, in our opinion, does not grant restitution whatsoever to the Commissioner. This will give, as I said, further time to vet these issues with your committee. What I am particularly worried about is in connection with initial enforcement actions. Most enforcement, I would say 99% of all the enforcement actions that are dealt with in this state are in fact settled without a final administrative hearing and order. One of the reasons for that is the expense in order to bring such an action and for the producer to have to go through that. Same thing for insurers. Settlements do work. Restitution in settlements do work. But to give the power, the ultimate enforcement power to order restitutions and enforcement actions will create an ability for the department to actually leverage enforcement actions against producers and insurers. Remember, this bill does not only award restitution, it awards reimbursements for costs and attorney's fees. That is something that for producers, 3,500 licensed producers in the state, they cannot afford to reimburse the department for attorney fees and costs. Also, it will ensure that the department can now bring numerous other actions, because the department can go out and hire other attorneys to represent it on its behalf and bring actions. So we are concerned about the ultimate effect of the bill, but basically we believe the bill legally is not, will not meet judicial scrutiny with regard to its legitimacy.
Thank you very much for that. Another opposition testimony?
Mr. Mr. Chairman and members, John Norwood on behalf of the insurance brokers and agents of the West. I heard previous testimony with regard to the Commissioner's desire to have authority to order restitution because of actions of insurers. We represent producers, agents, and brokers in California, and certainly many insurers have the ability and the resources to respond to administrative actions of the department. As Mr. Hogaboom just indicated, it's a much tougher thing for an individual producer to be able to represent themselves and go through that particular process. We think the current system allows the Commissioner to bring administrative actions, and through the fact that the Commissioner has the power to, pull your license and/or impose, fines and penalties. Oftentimes, a settlement can be developed where restitution is achieved. We think that system works today. With regard to this bill right now, we're very concerned about the broad definitions, of restitution, of economic harm, of all future regulatory costs, those types of things. And again, maybe with time we can work those out, or maybe we want to narrow this bill so that it doesn't indicate all licensees of the Department of Insurance, which technically would come down to, agents that are such limited agencies, capacities as rental car agents, of electronics agents, of credit life agents. I mean, not large brokers and operations like that. So for those reasons, we'd be opposed to the bill at this time. Thank you.
Thank you very much.
Mr.
Yes,
Chair, member Stephen Lindsay with the California Association of Health Underwriters. We too share the concerns that have been voiced today.
Thank you. Would anyone else like to come up in opposition?
Mr. Chairman and members, Ted Angela with the Association of California Life and Health Insurance Companies. And I just wanted to reference that I thought the analysis was very thorough and highlighted a number of questions that we feel need to be addressed. So we appreciate Senator Evans giving us the opportunity to talk through those issues with the Insurance Commissioner and his staff. Thank you.
Mark Zeckman with the Association of California Insurance Companies. We appreciate the opportunity to work with the Senator and staff and the Commissioner's staff to see if we can work something out. Thank you.
Thank you very much. Does that conclude the testimony? We are still, we do have a question by Senator Weiland. Sir?
Just a comment on just two issues. One is fairness, and I think
Senator, I just want to interrupt you. Sure. This is just testimony only. Okay.
Understand.
Thank you.
I heard you at the outset, and I think that's.
Want to make sure you knew that.
I think it's a good way to go, and I'm glad the author and the Insurance Commission decided to take it that route. One is simple fairness in these decisions, and the problem that I experienced as an employer is that sometimes government agencies were pretty good. I'm not one of those people who expects government to be as efficient as private sector. It isn't. It can't be. It just, we shouldn't expect that. But it was okay. But there's other times where it's arbitrary, capricious, and you're always wrong. So I could give you really egregious examples that have the opposite effect from, and I'm just picking government agencies at random. EDD. I used to go there when there were truly egregious cases on our part. I just stopped. There was never, ever any way. We had an employee steal from us. Steal. Wins it. It just at some point. So one of the issues I think that, and I'm not sure how you solve this, and I think that's what the other testimony is saying is, if your only remedy is to go to court, that makes it pretty tough. And the second thing is that there's no free lunch. So I think a really honest approach to not only this, but a lot of the rules and regulations we have would be to say, we think these are valuable and good. And they will cost X amount, because the private sector, that's providing goods and services, has to absorb that in some way. And indeed, they have a fiduciary duty to their shareholders, many of which are CalPERS, STRS, all of us. And so I just think as you go through this, there is going to be, could be an increased cost and burden on the insurance companies. Now, what makes this different is they've got to go through the department for their rating. I wouldn't want to create, in the attempt to make things better for the consumer, which I think is the right thing to do. And I've also been a consumer of insurance, and I've been on the other side, to inadvertently do something that happened with work comp, where I was there when all the work comp insurers were driven out of the state. The state fund, which is supposed to be the insurer of last resort, instead ran wild, picked up all the business, and of course there was no control because at the end of the day the state was responsible, undersold, underbid everyone else, and then we went from paying $100,000 to $800,000. And the effect of that is to reduce the profit by $700,000 more, and therefore reduce the tax paid to the state just on that one item, the revenue that we want, by $70,000. Because of monkeying around with that system, which was done with the intent of making it better. So, good luck with this.
Thank you. I was going to ask if there was a question there somewhere. Thank you.
Well, I did want to respond a little bit to the Senator's remarks. Senator, I have been an insurance defense counsel. I have been a consumer attorney. I have been a consumer of insurance products. I spent 25 years married to a workers' comp insurance defense lawyer who is now an ALJ. And so I have a lot of experience in a lot of different areas of this industry. And your comment about the potentially increasing cost to insurers, I think is one that we should not take lightly, because the practicality is if costs to insurers go up, cost to the consumer goes up. But it is interesting in listening to this discussion that there's concern about the fact that perhaps there may be some administrative remedies that allow for restitution by the insurance commissioner. On the other hand, if the insurance commissioner doesn't have the ability to make restitution, the only other remedy is to go to court, which thereby increases the costs both of doing business in the state of California and the cost to the consumer and the cost to the state of California as well. So, I mean, we're kind of going around in circles here, and what we're trying to do with this bill is cut through all that and provide a remedy that is short of the remedy that the commissioner currently has, which is of revoking the license to issue insurance in the state of California, and provide something in between that makes sense from a cost standpoint, both for the industry and from a consumer protection standpoint. Now, I'll agree there's a lot of details to be worked out on this, and that's why I've spent a lot of time with the insurance industry working through some of their particularly due process issues, because we want to make sure the process is transparent, everybody knows what the rules are, and it's fair to everybody. So that's what we're trying to do, is address a lot of the issues that you raised, a lot of the issues that the opposition raised. But I also still think it's really important that the insurance commissioner have the tools he needs to have in order to make sure that this is a fair, transparent process. And so that's what we're going to spend some time trying to do.
Thank you, Senator. Mr. Commissioner, did you have any other remarks that you would like to add?
I could not have said it better. I would just provide one brief example for the Senator, though, and that is there were a number of health insurers that engaged in medical rescissions. That is essentially post-claim underwriting, where they wrote insurance policies, they took people's money month after month, year after year, and then when people made a claim, they not only denied the claim but rescinded their insurance policy. That practice, there were enforcement actions brought by my department for insurers doing that. And the anomaly was that while was able to, not me, but the department, my predecessor, was able to impose a penalty, and there were quite a number of Californians that suffered this injury, and as a result, paid out of pocket for health treatment that should have been covered by the insurance, but the insurance was rescinded. The former insurance commissioner could not order restitution for those people. So what did they do? They all went out, they found a lawyer, and they brought a class action lawsuit against the insurance company. I suggest to you, as the good senator has said, that's far more expensive, far more onerous. The kinds of damages available in that context are far more burdensome potentially in the industry. If the insurance commissioner had the ability to order restitution, they wouldn't have had to go to that resort. And so that's just one example, and there are legions, but we don't have time, of examples where restitution for out-of-pocket expenses would be far less expensive on the system than pushing consumers and businesses to a court remedy to find a lawyer to bring a lawsuit against a company that has aggrieved them.
Very good point. Mr. Vice Chair, you had a comment or a question?
I had some comments. I guess I worry about this separation of power issue because it appears to me that you're playing both the judge and the jury. And basically what we're doing is we're giving more power to the insurance commissioner on issues that typically or historically have been handled by the courts. And as an insurance agent, I know that we are fearful of the Department of Insurance, and we strive to do our best because we don't want to lose our licenses to perform our duties as agents. And so I've got some real concerns as to, maybe the separation of power makes sense in terms of kind of the balance of power that we believe in our constitutional institutions here in California.
And I think that is something to always bear in mind. I mean, the legislature is a branch of government, as is the judiciary, as is the administration. And we need to be careful not to overstep each other's constitutional authorities. But over time, historically, in California as well as other states and the federal government, a body of administrative law and administrative process has grown up. And the purpose for that is to relieve some of the pressure on the courts and to provide a forum for people to redress their grievances and their wrongs outside of that judicial system, because it is so cumbersome and so burdensome and so costly. So the authority that the insurance commissioner has is really no different than any other agency, any other state agency. And the bill is trying to build in safeguards so that if something does go sideways with the insurance commissioner's decision or the process, the judicial branch is still there. You can still resort, either the insurance carrier or the consumer can still resort to the judicial branch.
But are you creating an inherent conflict of interest? I mean, when the insurance commissioner has the ability to approve rates for an insurance company, and you have a situation, a challenge on whether restitution ought to be granted or not, aren't you always going to have the insurance companies have to agree to whatever the insurance commissioner is demanding because he's controlling that process?
No, and let me assure you they don't. My agency, as well as many other California state agencies, already have quasi-judicial power. And even as the opponents testified to, I have the authority. I have a room full of administrative law judges who adjudicate enforcement actions brought by my department. And these enforcement actions allow us to garner penalties, fines, or to go so far as you pointed out, to take away the license both to sell insurance or to produce insurance in the state of California. To me, that's the neutron bomb. But so I already have that quasi-judicial authority. The California Constitution recognizes that agencies can have that authority. We're already there. The question is, will you allow me to have a remedy short of the neutron bomb? Will you allow me to have restitution as a remedy so I don't have to always go to taking away the license, which I think is the neutron bomb for both for producers and for insurance companies, so that I can provide relief to consumers and businesses who are aggrieved, short of threatening to take away a license and then leveraging that to get a settlement where I get restitution. I mean, there was a lot of talk about leveraging earlier. The real leveraging that goes on is I got the neutron bomb. Wouldn't it be better if instead of always relying on the neutron bomb, I had a more narrow cast remedy of restitution to try to resolve problems?
Okay. seems like there's still an inherent conflict of interest with that, because you've got rate approval authority.
Well, it's part of the regulatory authority. I mean,
It already exists.
right, it exists. It's part of regulatory authority, and it's part of the ability to enforce those regulations. And what the bill does is try to close what I would characterize as a gap in that authority, and that gap being defined as the ability to order restitution as opposed to going as far as revoking a license.
Okay. Well, we can continue to discuss it.
Sure.
I appreciate
There's
it.
a lot
Thank
to
you.
talk about.
Yeah. Thank you.
Mr. Chair, I appreciate all of the time that you and the committee members have spent today.
You're very welcome, and I want to thank
And the staff.
everyone for their testimony today. I also want to join with Senator Evans in providing the tools that you need, Mr. Commissioner, to do your job effectively, protect the consumers of the state. We've heard a lot of concerns, which basically means that we just need to tighten up some of the language and make sure there's no unintended consequences that are inherent in the bill, which happens quite often. The separation of powers issue really needs to be addressed to make sure that we're providing the proper justice to consumers in the state. And I look forward to working with you and with the Commissioner ongoing in achieving the service that the state provides and the state should provide for these people. So thank you so much.
Thank you very much.
Thank you, Mr. Chairman.
I don't see any other authors here. We are still a subcommittee. I do have some bills I can present on my own, so I can hand the gavel over to our vice chair, and I'll proceed down to the microphone. Before we go any further, though, I would like to acknowledge my appreciation and congratulate Inez as this is a Professional Assistance Day, and I want to thank you for your service to the state and for your service to this community. Let's go down there. Yeah. I think this is all I need. I'll take, yeah, okay, okay.
Senator Calderon, could you just clarify which bill you're going to present first?
Sure.
615.
615.
Great, thank you.
SB 615.
Okay, so that's file item number 4, Senate Bill 615. If you can please proceed. Thank you.
Okay, before I do want to thank the opponents of SB 615 for their thoughtful input. I understand and am sensitive to their concerns. They have engaged my staff in honest and straightforward dialogue regarding the bill, and as a result, I've received proposed amendments this week, which I am reviewing. So in essence, the amendments proposed increased training requirements for all people offering health insurance or health plan placement advice. And these amendments have been circulated to all the stakeholders for review. And while I'm not prepared to accept them now, at this time, my staff will analyze them further to prepare for the next hearing on this bill, which I believe is in Health Committee, will go to Health. And I'm confident there will be a compromise reached. Having said that, I want to present SB 615 today. The purchase by a consumer of a health plan, whether via a health insurance product or a health care service plan, is a serious matter with serious consequences. For this reason, consumers need a basis for confidence in those persons selling health care service plans. Now, all 49 other states require that one be a licensed agent in order to sell insurance products or health care service plans. In California, one must be licensed and licensed agent in order to sell health insurance products, but there is no such requirement for health care service plans. Senate Bill 615's goal is to prompt a review of this licensure gap under California law. As introduced, it proposes requiring all persons who transact, as defined in Section 35 California Insurance Code, who transact healthcare service plan and related products to be licensed by the California Department of Insurance as an accident and health agent. As discussions on the bill initiated with all interested parties have proceeded, I have learned in the last 24 hours proposed changes which would ease concerns of some opponents. And while those amendments were received too late for any analysis, as I previously mentioned, I am open to them and expect they will be a key part of the discussions in the Senate Health Committee. With that, I ask for your aye vote.
Great, thank you. If we could go ahead and speak to witnesses in terms of testimony and support.
John Lovell with the California Association of Health Underwriters. Collectively, health insurance agents are responsible for enrolling the majority of people in California for health insurance. They also have a key role in providing backup for their clients whenever there are coverage disputes with the carrier. It's a terribly important role. As Senator Calderon says, the purchase of a health insurance product is really a life-impacting decision. This bill recognizes that by requiring licensure, by closing the licensing gap, and it's particularly timely at this point. We are on the verge of expanded health care coverage. An estimated 4.7 million people currently not covered, currently not having the purchase of health insurance as part of their culture. And it's imperative that they obtain those products from people who are trained and licensed and who can be held accountable. And that's the gravamen of this bill. We also have looked at the amendments only yesterday. We believe that they form the basis for continued informed discussion. And we think that this is a bill that is a work in progress and can yield positive results for consumers.
Great, thank you. Other comments?
Mr. Chairman, members, John Norwood on behalf of the insurance brokers and agents of the West. It's a producer trade association representing independent insurance agents and brokers throughout California. As Senator Calderon indicated, California is literally the only state in the union that does not require by law that insurance agents sell HMO products, but they do insurance products. In all their states, both HMO and PPO products require the services of an insurance agent or broker to transact insurance. However, California over the years has essentially de facto enforced that through the fact that most of the big HMO carriers have wanted some level of protection and have required their sales force to have an insurance agent's license, despite the fact that the law didn't require it. And that has worked well, and I think, by and large, that system's worked very, very well over these years. But as indicated, we're on the verge of healthcare changing throughout this country. It was noted by the other witness that proponents indicate that there's 4.7 million, people that will be at some point looking to buy healthcare in the future. Primarily, these people are individuals and not businesses. Today, it's really more of both PPO plans and HMO plans are being sold to groups and businesses and have some ability to protect themselves. We don't know going into this kind of new future of healthcare who the providers are going to be, who the sales force is going to be, or who's going to target these individuals in terms of selling them products. We have people today that have their discount cards for health insurance, all kinds of other things that sometimes are real and sometimes are scams. programs. So we think that licensing adds a value to this. It provides a pre-licensing education on products. The Department of Insurance does a background check, which includes fingerprinting. In fact, we're one of the only states in the union that does fingerprinting, so that this department, and we've actually resisted the changes throughout the country not to do that, so that this department can make sure that we don't have felons and child abusers and this and that, going into people's homes and selling insurance products. So that's one of the bases. We also have continuing education requirements, and of course, the license fees that are paid by insurance agents help fund the Department of Insurance, their consumer protection and outreach services, and any efforts by the department to go after bad actors. For all those reasons, we think it's it makes sense to kind of close, as indicated by Mr. Lovell, that licensing gap as we go forward. I think that the opponents have raised some real good issues in terms of this, and we'd be happy to work with them in that regard. And as this bill is double referred, the next stop on the train is Health Insurance, our Health Committee, and so we look forward to continuing the dialogue.
Great.
For those reasons, we'd ask for support.
Thank you, Mr. Norwood. I think we do have a quorum. I'd like to take a roll call vote here real quick, and we'll get back to witnesses in support.
Calderon?
Here.
Calderon present. Gaines?
Present.
Gaines present. Anderson? Corbett? Corbett here. Correa? Liu?
Here.
Liu here. Lowenthal? Price? Here. Price here. Weiland? Price, Weiland here.
Great. Thank you. Witnesses in support.
Thank you very much. Sherry McHugh, representing the National Association of Insurance and Financial Advisors. We, too, support the bills very strongly. We believe this is a consumer protection issue. As we just saw with the previous bill, we have a commissioner that is very good at taking enforcement actions against rogue agents, rogue companies, and we believe that the 4.7 million individuals that will now be shopping for insurance deserve the same consumer protections that they would be able to benefit from if it was a PPO product or an HMO product. We think a level playing field and those consumer protections are very important, and we support the bill. Thank you.
Great, thank you. We have a question from
Mr. Chair, I'm so
Corbett.
sorry to interrupt the train of thought here, but can we also hear from the supporters? There's some amendments that were discussed that are sort of on the table, what their position is on those amendments as we go through?
Sure, you bet.
Thank
Absolutely. Great.
I would just indicate I can't talk to each particular amendment. But we just saw them yesterday, but the idea, I guess, is to try to create similar type education, training, background checks, et cetera, in the Department of Managed Health Care, and perhaps address some issues in that way. Perhaps that works. I don't know if that department's, is set up to, the Department of Insurance has, 1,300 employees and has quite an enforcement division. I don't think that DMHC is anywhere close to having that ability. We have 350,000 plus insurance agents in California, and how many more that are solicitors that are selling other non-insurance products. And I think actually HMO products are the majority of healthcare in the state. So some of those ideas are worth discussing. I think one of the issues was also to talk about, the current license is an agent's license, and when you're an agent of the company. There's been some discussion about, is the duty to the customer, is the duty to the agent, or to the insurer. We'd be more than happy to make that license a broker agent's license, like the property casualty agent's license, so that in fact you can enter into agreements and be a broker and have that duty, first duty to the customer.
Okay, thank you.
Sure.
Great, wonderful. Other witnesses in support? Okay. Witnesses in opposition?
Beth Capel on behalf of Health Access California. We'd like to begin by thanking the chair and the committee staff, and also the chair's personal staff, as well as the sponsors, for having worked with us in a very constructive and thoughtful manner. We're very appreciative of the effort to understand the larger issues. As the author and the sponsors has indicated, this bill comes to you in the context of national health reform, which is a transformation unlike anything I think most of us have seen in our professional careers. Of the 4.7 million Californians who are going to be newly insured, most of them will not be buying coverage as individuals. Many of them will be taking up employer coverage that was previously offered that they did not accept. Of the, at least 2 million of them will be covered by Medi-Cal. Another 2 to 3 million of them will be getting coverage through subsidies on the exchange. So while some of them will be taking advantage of the opportunity to buy coverage as individuals from various sources, many of them will be getting coverage from other sources. Second, 80% of health insurance in California is actually regulated by the Department of Managed Healthcare as healthcare service plans. Since 1975, the Knox-Keene Act has regulated healthcare service plans. Solicitors, who are the ones who sell healthcare service plans, have not been required to be licensed agents and brokers. And although some healthcare service plans may have chosen to use agents and brokers, that hasn't been required. The structure of regulation and oversight at the Department of Managed Healthcare is quite different than the structure at the Department of Insurance. For example, all marketing material is subject to prior approval. Just a different structure of regulation. And so we looked at the actual language of 615 and tried to think about it and said, if the intent here is to provide greater consumer protection, which is what we understand from the author and from the sponsors, then why don't we propose that there be comparable training and education for the people who are actually selling healthcare service plans? And that seemed to us a reasonable protection. And the amendments that we offered yesterday, and we apologize that they are late in the process, but it is that time of year, propose that. We are happy to talk with the author and the sponsors about other requirements that are currently in place at CDI, but we thought it was odd to have the Department of Insurance regulating people who sell Knox-Keene plans that are regulated by the Department of Managed Healthcare. California is the only state in the nation with 2 regulators, and it creates a number of challenges for us. We've long supported a single regulator. We don't think that's what this bill was intending to accomplish. That seems somewhat more ambitious than what this bill was. But we would, look forward to working with the author and the sponsors between now and Health Committee to try and resolve the amendments. I would just add on behalf of AFSCME, which is my other client that has spoken up on this, we represent the workers at Kaiser, some of whom also sell Kaiser products as employees. And so it seemed to us asking them to be licensed agents was again, we just have the 2 regulator structure in California that creates some challenges. So we would look forward to working with the author and the sponsors between now and Health Committee to resolve our concerns.
Thank you, Ben.
Great, thank you. Other witnesses?
Hi, I'm Allison Lobb with California Children's Health Initiatives, and I'm speaking today on behalf of my organization and the 28 Children's Health Initiatives across the state, and also on behalf of PICO California, United Ways of California, and the 100% campaign, which is a collaborative effort of the Children's Partnership, Children Now, and the Children's Defense Fund California. And our position does remain oppose unless amended, although we are very happy and grateful that the Chairman Calderon has included an amendment that exempts the Navigator program under the California Health Benefits Exchange. But because we continue to have other concerns with SB 615, we currently oppose the bill unless amended to address a number of issues, including amendments to ensure that accident and health agents have a fiduciary duty to the consumer, not insurance carriers or managed care plans, and amendments to require training that covers both public and private programs. And we are hopeful that our groups can continue to work with the author and the co-sponsors to amend the bill to ensure that SB 615 protects healthcare consumers. Thank you.
Great. All right. Other witnesses in opposition?
Good afternoon. Brianna Learman-Hinsey on behalf of the Local Health Plans of California, which, as the name implies, is a coalition of local, nonprofit, county-based health plans. Our member plans do not use brokers to solicit their plans. They use community-based organizations, and come 2014, they hope to use navigators to perform a lot of this function. We have informed the sponsors of this bill of our desire to completely exempt navigators from this broker requirement. The current exemption is a limited one. It applies to the education activities of navigators, when in fact, as we read it, there are many activities that the navigators can undertake, including facilitate enrollment in plans, provide culturally and linguistically appropriate information. And we want this, we desire to have this complete exemption built into the bill for those navigators. Our member plans are nonprofit. They cannot absorb the fees associated with brokers. And for that reason, we would ask that the navigators be exempted from this requirement. We look forward to continuing our discussions with the sponsors on our desire to achieve this amendment. Thank you.
Okay, great. Thank you. Any other witnesses in opposition?
Kathleen Hamilton with the Children's Partnership and the 100% campaign. Pardon me, our position is opposed unless amended as well.
Okay. All right. Very well.
Vanessa Kahina with the Western Center on Law and Poverty. We are also currently listed as opposed unless amended. We would concur our comments with those of Health Access California and the local health plans in terms of the organizations that we represent being unable to absorb the broker's fees that come along with this bill. We are very heartened by the amendments taken to exempt navigators and continue to look forward to working with the author and the co-sponsors.
Great. Thank you. All right. Any other witnesses in opposition? Okay. Questions, comments? Senator Price.
I want to just thank the author for bringing this forward with the prospect of health care reforms. Obviously, it's going to be a critical element, and I think it's encouraging that you're willing to work with the opposition, obviously, to resolve the issues. I got just a question. What's a navigator? I keep hearing this navigator term.
I think it's a Lincoln, isn't it?
May I?
Yes, please.
Senator Price, Beth Capel on behalf of Health Access again. Last year, this legislature and the prior governor enacted legislation creating a health benefits exchange and gave the health benefits exchange the responsibility to answer that question. I think we're all waiting for the federal guidance to tell us exactly what a navigator is, but I think generally it's envisioned to include community-based organizations and a wide range of other organizations as well as agents and brokers. So, and thank you. And helping people navigate the health system. So it's
that makes
thank
sense.
you, Ken.
In there, Lincoln.
Clear as mud.
Great. Senator Corbett.
Thank you very much, Mr. Chair. Two questions, just so I understand what's in the bill now. So the amendments to exclude the navigators has been taken?
That's already in.
Okay. And then there is other amendments that have
It excludes the navigators from the
I see people shaking their heads no.
Ongoing education, right? But not entirely.
Right. The exclusion applies to government code number L1, and that applies to education activities, but I believe there's 5 to 7 other activities that these navigators can engage in. So that goes to my comments that the exception's pretty limited. We wanted to see a complete exception.
So
Senator.
So those amendments have been taken, and then there's other amendments that
Senator, with respect to the navigator amendments, when we put those in, we actually took the actual language of one of the opponents and put it in, and it now develops that language has to be broader, which we're obviously willing to work with everyone about. The amendments that were put in yesterday deal with presented. Thank you. Deal with a number of other issues involving education requirements, involving the Department of Managed Care, and those amendments are the germ for serious discussion. They frankly came in too late from our perspective, through no one's fault, okay, for us to be able to give you a threshold response to them today. But I will tell you that we will be sitting and talking with the proponents of those amendments with an objective toward coming to consensus.
Okay, very good. I'm very interested in seeing those amendments be included, and I would assume you would consider them in the Health Committee?
Yes.
Absolutely. Are you committed to accept them, Senator?
We've already made that commitment to the opponents.
Okay, very good.
Senator Corbett, is that acceptable?
Yes, absolutely.
Okay, very well, great. We have another question from Senator. Thank you.
Just a comment. I think this is a really good bill, and from many, many years of experience buying health insurance products, not just as a consumer, but as a business, the reality is that brokers serve a really important service, and I have a little bit different view that cannot be performed by those who are less experienced. They just can't. And to use an example on the commercial level, when Kaiser didn't use brokers, they didn't sell much insurance outside a relatively limited market.
Yeah.
Once they used brokers who could explain the products, who could help them properly price the products, who could really, walk you through it, they did better. And you could make the argument, that in terms of protection of the consumer actually gets better protection because you have someone who has actual expertise. So anyway, I understand that there's going to be changes and all that, and I appreciate the author bringing this forward.
Okay, other questions or comments from the committee? All right, we need a motion then? So moved. Okay. Would you like to go ahead and make closing comments?
Yeah, just, simply put, the purchase of consumer health plans, it's a serious matter and could have dire consequences if someone that's not properly trained is writing these policies. It's because of this, consumers need a basis for confidence in those persons selling the health care and selling service plans. 49 other states already require that. I don't see why we shouldn't just be uniform and provide the same protection. And with that, I ask for your consideration today in your aye vote.
Great. If we could have a roll call vote of Senate Bill 615.
Calderon?
Aye.
Calderon, aye. Gaines?
Aye.
Gaines, aye. Anderson? Aye. Anderson, aye. Corbett? Aye. Corbett, aye. Correa? Blue? Aye. Blue, aye. Lowenthal? Aye. Lowenthal, aye. Price? Aye. Price, aye. Wyland? Wyland, aye. That measure has 8 votes, and it's out.
Thank you very much.
Right, thank you. Wonderful. And we'll go ahead and leave the roll open for any missing members.
Okay. Great. May I do SB 713 next?
Absolutely. Yeah, could we do consent calendar real quick?
Please.
Let's get that out of the way.
Read my mind.
Great. We have a motion for the consent calendar. Roll call, please.
Calderon?
Aye.
Calderon, aye. Gaines?
Aye.
Gaines, aye. Anderson? Aye. Anderson, aye. Corbett? Corbett, aye. Correa? Blue? Aye. Blue, aye. Lowenthal? Lowenthal, aye. Price? Aye. Price, aye. Wyland? Wyland, aye. That has 8.
Great, 8 votes. That's out. We'll leave that open for any remaining members. Item 7, Senate Bill 713. Senator Calderon, if you could present.
Yes, I will. Just to make a note, SB 713 is also co-authored by Senators Anderson, Senators Corbett, Correa, Vice Chairman Gaines, Senators Lowenthal, and Wyland. I want to thank you all for your input and your participation. SB 713 it's a companion to Senator Kehoe's SB 599, which is the retained asset account bill. It's in a proper form to be enacted in tandem with hers, and while Senator Kehoe's provides important new disclosures to Californians consumers about their rights in connection with life insurance settlements, SB 713 adds new disclosure rules that apply at the claim time if a retained asset account is established for a beneficiary. You will have testimony today explaining exactly what an asset account, retained asset account is. Under current law, there are no clear disclosure requirements. SB 713 is based on model disclosure rules adopted last year by the National Association of Insurance Commissioners. Beneficiaries will receive information on key facts and features of any retained asset account which is offered to them at the time of a claim. The bill differs slightly from the NAIC model by adding a requirement for at least quarterly statements on the status of the funds in the RAA, retained asset account. The analysis suggests one amendment to track some SB 599 language, and I agree to that end. A motion on SB 713 should be due pass with suggested amendments to be taken in Senate Judiciary. With that, I ask for your aye vote.
Right. Thank you. Okay. Witnesses in support, please.
Yes, Mr. Chairman, committee members, Brad Wenger representing the Association of California Life and Health Insurance Companies. We are in support of the bill. The basic fabric of the bill is what's recommended by the National Association of Insurance Commissioners. Adds important disclosures. Also, through discussions with the Department of Insurance, there are, as the author mentioned, the quarterly disclosures and some extras added into that. So we would urge your support for the bill. We will also be supporting the Keogh bill today, which adds a separate disclosure regarding the default option for a retained asset account, which we think is a valuable consumer option.
Great. Next witness, please.
Thank you, Mr. Vice Chair and members. For the record, my name is John Mangan, Regional Vice President of the American Council of Life Insurers. We're the national trade group, many of Mr. Wenger's same members. We also support Senate Bill 713. Retained asset accounts are really more accurately described as claim fulfillment accounts. These are accounts that are the full payment of a death benefit into an account that pays usually a guaranteed rate of interest that's very favorable to the consumer, and it's pegged to the date of death, not just the date of the claim approval. A very beneficial option for people to take advantage of, very popular in the marketplace, has not generated any complaints we know of in the states that have been using it for the last 25 years. But we support strong disclosure. We want to make sure there's no confusion about these accounts for consumers, and therefore we support the disclosures that are in the bill.
Great, thank you. Other witnesses in support? Okay. Witnesses in opposition? Or neutral?
Third category, yes.
Neutral.
Michael Martinez, Deputy Commissioner and Legislative Director for the California Department of Insurance, and we have no position on SB 713, yet we do want to really thank the author and the author's staff and just a plethora, the sponsors, really everyone. It is a bill that's going certainly in the right direction, and we do believe that we view this bill as a companion to our sponsored bill, SB 599 by Senator Kehoe. And so I think there's one or two more issues that we continue to work on. Yeah, this is certainly a step in the right direction. I want to thank a lot of the amendments reflected. We've worked with the author's office on. So again, thank you.
Great. Thank you. Okay. Any other witnesses in favor, opposed, or neutral? Okay. All right, questions? Oh, okay, we have a motion. Question? Yes.
So one of my concerns with this bill is, consumers have a choice, whether have this account or to maybe take the money and put it in a bank. When you walk into the bank, it's very clear, they drill into your head that your accounts are insured up to $250,000. So folks that leave their money in these retained assets accounts may have money well in excess of what their state guarantee insurance levels are. And if the consumer knew that, they actually might choose to take out a portion of it or all of it, because if the insurance company all of a sudden went under, they would actually lose the entire amount. But I am working with the supporters of the bill, and they've been very open, and so hopefully we can get some language that makes sense. But I'm going to be supporting the bill today, and thanks for the bill.
Oh, thank you. Thank you for that observation.
Great. Thank you, Senator Liu. Any other questions? Okay, we have a motion.
A motion with the amendments to be taken in judiciary.
So this is due pass with the suggested amendment to be taken in Senate Judiciary. Roll call, please.
Calderon?
Aye.
Calderon, aye. Gaines?
Aye.
Gaines, aye. Anderson? Corbett? Corbett, aye. Correa? Liu? Liu, aye. Lowenthal? Lowenthal, aye. Price? Price, aye. Weiland? Weiland, aye. That measure has 7 votes.
Okay, we'll leave that open for other members. Wonderful. And we'll go ahead and move on to item 8 then, is that right?
Yes, SB 715.
Okay, great.
If you'll bear with me, Mr. Vice Chair and members, My presentation is a little long, but this is a very important piece of legislation, and I think it's important that we're very thorough on explaining what exactly this accomplishes. I am very pleased to present SB 715 to you today. In my view, the bill's subject matter will end up as the most important body of law our committee will consider this year. Annuities are vitally important in today's economy because they give people a way to pay money now in order to secure revenue over time. And they are, however, complex financial tools. The most important fact about annuities for this committee to note is this, that not every annuity is a good fit for every buyer. Due to this complexity, for over 10 years, regulators nationally have worked in a legal framework that can protect consumers by requiring, as annuity sales occur, that producers and insurers are selling suitable products. Back in 2003, the early efforts on the National Association of Insurance Commissioners aimed just to protect seniors. By 2006, as it saw growth in the complexity of annuities, the NAIC updated its model to protect buyers of all ages. However, despite 6 attempts since 2003 and the vigorous efforts of Senator Jack Scott, none of these model annuity suitability laws were adopted in California. This year, both SB 715 and its Assembly counterpart, AB 689, are dramatically stronger than any law this body has ever considered. The number of factors to be used in suitability analysis has jumped from 3 to 13. Training requirements for procedures are increased. And for the first time, insurers are subject to a clearly unenunciated duty to maintain procedures that protect against issuance of unsuitable annuities. Given previous failures, I've been asked, why do I foresee success now? Well, the biggest change is that when the President signed last year the Dodd-Frank Wall Street Reform and Consumer Protection Act, that act urged states to adopt this NAIC model. I agree with the President and the Congress. The adoption this year of a strong annuity suitability law will benefit every Californian. I'm asking for your aye vote on this bill today because it was our committee which, with this bill's introduction, set in motion the 2011 annuity suitability conversation. As the year proceeds, I anticipate that the bill will send to the governor will be AB 689 rather than SB 15. I feel that way because AB 689 is Commissioner Jones's bill. He's entitled to claim ownership of this important advance in consumer protection. In due course, I expect to be supporting AB 689 when it appears in our committee. But today, I invite your support to this measure, and indeed I would welcome to add any of you as co-authors who wish to join me because it was our panel that was first out the gate on this issue during the current session. There can be no doubt that if, as I expect, an annuity suitability bill is passed this year, it will be due to the decisive and early leadership of our committee and staff. With that, I ask for your aye vote.
Great. Thank you, Senator. Do we have witnesses in support?
Okay.
Mr. Vice Chair, committee members, Brad Wenger again for the Association of California Life and Health Insurance Companies, and we are in support of this measure, which adopts the fabric that was developed over a long course of time by the NAIC. We were a participant with the Jack Scott bills and all of the lead up to the point that we are now, and we're pleased to be in support of what the author described as a very complete system of supervision towards the sale of annuities, not just to seniors, but all consumers. And you know, this is one that we've worked long and hard on, and we worked with the Department of Insurance, and we would recommend that it move forward. It differs from the NAIC in some respects, but all in all, it is what has been recommended, what's been adopted in other states, and really to me, represents an evolution within the industry, and a responsible one, where the sales practices were, if there were some sales practices that needed some adjustment, they have been addressed, and our regulators have been responsible, and we're pleased to support the bill moving forward.
Great, thank you. Next witness.
Mr. Vice Chair and members, again, my name is John Mangan with the ACLI. We also would echo Mr. Wenger's remarks and just note that this model bill that the Senator has introduced is very similar to the federal securities regulation that applies to securities and variable products. Very effective regulation that has reduced to a very small percentage the number of unsuitable sales in that arena, and we think the same will happen in California.
Great, thank you. Next witness.
Sherry McHugh, representing the National Association of Insurance and Financial Advisors. We are very pleased to support Senator Calderon's bill today. We've worked on this very important consumer protection issue for many, many years, starting actually with then Assemblyman Jack Scott. So it is really our pleasure to be here supporting the bill today. Thank you.
Mr. Chair, members, Stephen Lindsay with the California Association of Health Underwriters. We too are in support.
Great, thank you. Witnesses in support or neutral? Or?
Neutral. And I say that, first of all, Michael Martinez, Department of Insurance, and I really wanted to thank the chair, the staff, a lot of the committee members, really underscoring that we've been working in partnership with the Department of Insurance, the commissioner, a lot of the stakeholders, industry, consumer groups, et cetera. This has really been a multi-year collaboration, I'd say, to some degree, but also just there's certainly a lot of desire this year to see an annuity suitability bill going forward, and I wanted to underscore the commissioner's thanks to the chairman for his leadership and to the staff for their leadership in helping move this along, and an annuity suitability bill. And so just wanted to say that on this particular bill, we do not have a position pending. There are some distinctions between the bill, but again, all in all, in the intent and the direction of SB 715, it really is a huge step in the right direction. So with that, I want to again thank you, everyone.
Great. Thank you very much. Appreciate that.
Thank you, sir.
Any other witnesses? Witnesses in opposition? Okay. Questions? Yes.
As this committee understands, annuities can be enormously complex financial instruments. And prior to serving in the legislature, I litigated for 2.5 years the suitability of annuities when sold by financial advisors. And all I can say, Senator Calderon, is it is about time we did this. I thank you for your leadership on this bill, and I'd like to be added as a co-author.
Great. Thank you, Senator Liu. Other questions, Senator Weiland?
I echo those comments. It really is important. And just reading through those 13 criteria, they are really important. It is an area rife with abuse. It may be the right thing, the right product for the right person. And I'm pleased to be a co-author. I think it's really a good bill. I hope as it goes to the Assembly, they don't mess it up. Because it's a nice combination, I think, of protecting consumers, but also offering them something that some of them need or would choose. So thanks for bringing it forward.
Okay. Would you like to close, Senator Calderon?
Again, I just ask for your vote.
Okay, great. Wonderful. Do you have a motion? Yeah. All right, great. If we could please have a roll call vote on SB 715.
Calderon?
Aye.
Calderon, aye. Gaines?
Aye.
Gaines, aye. Anderson? Corbett? Correa? Liu? Aye. Liu, aye. Lowenthal? Aye. Lowenthal, aye. Price? Aye. Price, aye. Weiland? Aye. Weiland, aye. That measure has 6 votes.
6 votes, and we'll keep that open for other members.
Yes.
Thank you.
Thank you.
Thank you. Mr. Price, would you like to present your amendment? You have two, item number 1, SB 220, item number 2, SB 596. Your choice.
Welcome to take 220 first. Chairman, members, SB 220 extends the availability of optional group life insurance coverage for dependent children up to the age of 26. This follows changes taking place for dependent coverage under the Federal Patient Protection and Affordable Care Act of 2010. This bill would allow insurers to offer additional insurance for families in the event of a tragedy and would be an expansion of benefits at a time when many businesses are being cut back. There's no opposition, and I respectfully ask for your aye vote.
Very well, thank you. Any testimony, support?
Yeah, Mr. Chairman and members, Ted Angelo with the Association of California Life and Health Insurance Companies. We're pleased to be here to support the bill. A number of our member companies have been asked to extend the dependent coverage for up to age 26, consistent with the changes that have happened on the health side. This would allow that option to be offered to would allow the insurers to offer that coverage and would allow the employers to offer that coverage to their employees for dependents. Very straightforward, simple measure, and appreciate your support.
Thank you very much.
Sherry McHugh, representing the National Association of Insurance and Financial Advisors. We are pleased to support the bill. Thank you.
Thank you. Any other testimony in support? Seeing and hearing none. Any testimony in opposition? Seeing and hearing none. Any questions or comments by the committee? Hearing none. We have a motion. Call the roll.
Calderon?
Aye.
Calderon, aye. Gaines?
Aye.
Gaines, aye. Anderson? Corbett? Correa? Liu? Liu, aye. Lowenthal? Lowenthal, aye. Price?
Aye.
Price, aye. Weiland? Weiland, aye. That measure has...
Measure has 6 votes. We will keep the roll open. Item number 2,
Thank
Senator.
you, Mr. Chairman. Again, I'd like to begin by offering the amendments that were handed to you, that are being handed out by the sergeant as our
These are the
author's
insurance,
amendments.
Department of Insurance amendments?
Correct. Based on our conversations with the Department of Insurance.
Yes.
SB 596 aims to streamline several consumer notices, thereby reducing consumer confusion and providing easier access to relevant information. Each year, the insurance industry sends out tens of millions of disclosures in the form of paper. And some of these disclosures relate to the very same issue but are currently required to be sent in 2 separate mailings. The intent of SB 596 is to seek a better way to make some of those disclosures in a way that requires fewer resources and saves paper while maintaining important consumer disclosures. After conversations with the Department of Insurance, we agreed to drop one section of the bill entirely, and now are offering amendments that modify 2 of the remaining 3 provisions in the bill. Your support today will allow for more time to continue as we discuss ways to reach consensus on how to improve the overall efficiency by consolidating current insurance disclosures and other means of communication. Through recent discussions with the department, we have covered substantial ground. We'd like the opportunity to continue working with the department to remove the opposition and to address the remaining concerns, and respectfully ask for your aye vote.
Thank you, Senator. Testimony and support?
Mr. Chairman, members, Theo Pejos, representing the Association of California Insurance Companies. We got together with some of our member companies at the beginning of the year. A couple of those companies had done some outreach to their customers in a way to try to figure out if there was a more effective and less confusing way for them to communicate with their insureds. And the answer they got back was, you send us too much stuff. Well, we thought that sentiment, along with the new emphasis on sustainability and conservation of resources, that we should probably look at all the disclosures that we have to send out to our insureds and see if there were certain disclosures that we could make more effective. And we've identified the following. I believe the sergeant has passed you this packet. I'll go through this very quickly.
Could you, Mr. Pejos, give us an example of the type of disclosures that are received? Yeah.
Absolutely, Mr. Chairman. The first 5 pages of the packet that you were handed out is what's called the Unfair Claim Settlement Practices Act. It's a very important act because it specifically enumerates the type of things in claims handling that we're prohibited from doing. Currently, under current law, we are required to send the entire act to every insured that files a claim. The problem with that is that it is 5 pages of legalese that I think even those of you who do this kind of stuff every day would find very confusing. The part of the Act that is pertinent to someone who files a claim is actually on the middle of the 3rd page. It's not until you get to subsection H on page 3 that would pertain at all to an individual that's filing a claim. So we're sending out a 5-page notice to people. Only 1.5 pages applies to them, and our suspicion, and in fact the outreach confirmed, that most people have no idea what it is. So what we'd rather do than send out the entire Act is simply notify the customer after they file a claim that this Act exists, to refer them to the website at the Commissioner's office so they can read the entire Act if they want, and then offer to send them the condensed version, the condensed subsections that apply to them upon request. That saves us 5 pages of paper for every claim that's filed. There are about 7 to 8 million homeowner insureds in the state alone, so that would be a major savings in paper. The Department of Insurance asked that we send that back, we change that back to a 12-point font. Originally the bill had a 10-point font, so we did that. We changed it back to 12. It's going to be a page and a half instead of the page we had originally sought, but that's okay. The next disclosure is the offer of earthquake coverage that every homeowner insured gets. Who didn't get one? I didn't. Oh, you didn't get one. Oh, you might want one. That every homeowner insured gets when they sign up for homeowner insurance, and it's basically the requirement that the insurer tell them that they can get earthquake coverage for the CEA, and that goes into an envelope, a stamp gets put into it, and it gets sent to every homeowner insured. Then sometime later, there's a separate notice that has to do with the discounts that you can get with your earthquake coverage if you do certain things to your house. It's the same topic, earthquake coverage, yet we do 2 separate disclosures, 2 separate envelopes, 2 separate stamps. As you can see, it makes perfect sense for both of these disclosures to be in the same envelope with just 1 stamp, and we save 1 piece of paper times 7 million. That's 7 million pieces of paper, and that alone annually. It's the same subject matter. It should be in the same envelope. Right. Same thing for 2 other very important disclosures. I believe this was one of your bills, Senator Gaines, who's no longer with us, but it's the California Residential Insurance Disclosure Act. Very important disclosure. There is another disclosure called the California Property Insurance Bill of Rights. It just enumerates the Bill of Rights, the rights you have as a insured. Right now, 2 different mailings, 2 different stamps, 2 different envelopes, same subject. It makes perfect sense for those 2 to be in the same envelope. That's essentially the bill before you with the amendments, and we hope you can support the bill today.
Is there more testimony? Support?
Thank you, Mr. Chair. Manolo Platine, representing the Personal Insurance Federation. Just like to echo the comments of Mr. Pejos. We are in support. Thank you.
Yeah. Thank you very much. Any others here to testify in support? Any others here to testify in opposition? Neutral?
Michael Martinez, Department of Insurance, and I just wanted to thank the author, his staff, and the sponsors of the bill for our ongoing discussions to make the bill better. And I do concur that the most recent Ledge Council one-page amendments that you have were resulted from a very productive conversation that we had with the bill sponsors. And so I appreciate that. There are a few things that we still are working out, but we would completely support the bill going forward today. Thank you.
You are in support.
Oh, I would say we would support the bill going forward, but we have no position on the bill. Correct.
Okay.
Thank you for clarifying.
That got you there.
Good try.
Yes.
Paloma Perez on behalf of Consumer Attorneys of California. We're actually opposed against unless amended. We do appreciate the author and the sponsor's attempt to go green. However, we do have concerns that the bill in its current form does eviscerate the original intent of making these disclosures to the consumer. These disclosures, as the sponsors already said, are made at the time of the claim. So they are relevant information that a consumer does need to obtain, and we're hopeful that we can reach a compromise with the author and the sponsor that reaches the goal of going green while still making these disclosures to the consumer.
Okay, thank you. Any other testimony in opposition? Seeing and hearing none, we go to the committee. Any questions or comments? Yes, Mr. Weiland.
Just in regard to the disclosures and intent, I think I speak for many of us who are fairly sophisticated in this. I don't read all that stuff. I mean, the more streamlined, the better, and I actually think there's better consumer protection by making it more streamlined. So I think it's a good bill, and I'm glad we got it.
Okay, that does it on the comments. So we need a motion. The bill's been moved with the mocked up amendments. As amended. Okay, call the roll.
Calderon.
Aye.
Calderon, aye. Gaines. Anderson. Corbett. Correa. Liu. Liu, aye. Lowenthal. Lowenthal, aye. Price.
Aye.
Price, aye. Weiland. Weiland, aye. And that measure has 5 votes. And
We will keep the roll open. That has 5 votes. And you just experienced regulatory streamlining at its best.
Mr. Chairman?
Senator Kehoe, welcome.
Thank you. I appreciate your patience.
Oh, no.
They're hearing the foreclosure bill in the other committee. You remember that one?
Oh, boy, yes. Happy to have you here.
Thank you, Mr. Chairman and members. And, Mr. Chairman, thank you and your staff for working with me on this bill, making sure that this one and your SB 713 are in agreement with each other.
Yes.
Yeah. And I wanted to let you know that current law falls short of providing essential policyholder and beneficiary protections regarding life insurance payouts in some cases. And this bill, SB 599, protects consumers without imposing unfair or undue burdens on insurers. The bill's inspired by consumer complaints having to do with an expanding payout practice called retained asset accounts. And there are potential benefits to retained asset accounts, but there are also some aspects that have created problems for beneficiaries, in particular fallen service members. The bill is sponsored by the Department of Insurance. It's the result of cooperation between the industry and consumer groups and the sponsor. One industry group has removed opposition. Only minor concerns remain. We've had very good discussions with all parties, and we will continue to work with the industry to resolve the last concerns. My understanding is the committee is not proposing any amendments at this time. Michael Martinez from the Department of Insurance is here, and I'd also, if the committee pleases, invite anyone to be a co-author when we take the vote.
Thank you.
Thank you, Mr. Chairman.
Thank you very much. Hello. Mr. Martinez, are you neutral on this one?
No, we're actually in support. Thank
You're the
you,
sponsor.
Mr. Chair.
I hope so.
Yes.
It'd be a real
shocker. Hello, good afternoon. Michael Martinez, Department of Insurance. We are the sponsors of SB 599 and therefore in strong support of this bill. And to what our author, Senator Kehoe, has said, we do believe this bill does work and will work in close coordination with SB 713, the chair's bill. And really want to thank a lot of the discussion that we've had with stakeholders on this bill and in concert with your committee staff. So I do want to think that we do believe that retained asset accounts have features that may not always be suitable for a beneficiary. And so we believe beneficiaries should be able to have that choice. It is really about that consumer choice on whether or not a retained asset account is established for them. We want to ensure that beneficiaries are afforded the opportunity to decide how they want to be paid out. And so we do feel that the bill, as amended today, does capture that consumer choice. And so we do want to protect a beneficiary's right to choice and ensure that they're made aware of how their benefits will be paid if they fail to make that payment designation. So with that being said, we urge your aye vote on this bill, and I also have here Tony Signorelli, Deputy Commissioner of the Department's Consumer Services Market Conduct Branch, if members had a bit more technical questions on how this works. Thank you very much.
Thank you so much. Any others who'd like to testify in support?
Mr. Chairman, committee members, Brad Winger again for the Association of California Life and Health Insurance Companies. We do appreciate working with the author and her staff in this committee with the amendments taken both on April 14th and April 25th. We find ourselves in support of the bill. There are some technical wordsmithing compliance issues that we'll continue to talk about, but we urge you to move this bill forward.
Thank you.
Mike Montgomery with the Congress of California Seniors. We sent a second letter yesterday supporting the amended bill, and we do support that bill now.
Great. Thank you so much.
Paloma Perez on behalf of Consumer Attorneys of California. Just wanted to echo the comments made by the Department of Insurance. We are in support.
Thank you.
Mr. Chairman, members, John Norwood on behalf of Pacific Life and Liberty Mutual. We had previously sent an opposition letter, wanted to clarify for the record we now support the bill. Thank you.
I'm sorry. Your support? Support. Thank you.
Delia Children on behalf of Allstate Insurance Company. We are deeply appreciative that the author and the sponsor moved from the original requirements in this bill to the disclosure requirement today. We think the bill is moving in the right direction. We are supporting the bill. We want to point out that the company's technical people have a few issues regarding the form and the format of the disclosure, but we are committed to working with all interested parties to make sure that that is complied with and can be implemented by the company.
Thank you so much.
We're going to resolve that point size issue.
That's great. Great. That saves me a comment at the end. Any others here would like to testify in support? Opposition? Co-authors? I would like to be added as a co-author.
Thank
Senator
you, Mr.
Keehan,
Chairman.
if I may. Okay. We have a motion. Move the bill as it amended.
No, there's no amendments taken.
No amendments now. Okay. Call the roll.
Calderon?
Aye.
Calderon, aye. Gaines? Anderson? Corbett? Correa? Liu? Aye. Liu, aye. Lowenthal? Lowenthal, aye. Price? Price, aye. Wyland? That measure has,
How many?
it has 4. You only still.
Yeah. Call the absent members.
Anderson? Anderson? No. Wyland? Wyland? No. That measure has 4 to 2. You want to still hold it open?
Yeah, we will hold that open.
Okay.
At this, thank you very much, Senator.
Thank you.
Everyone. At this point, we are going to open the roll, starting with for absent members. Let's start with the first one and go numerically.
SB 220, the present vote is 6-0, and the motion is due pass to the Senate floor. Anderson?
Item number 1.
Item number 1, 220. Anderson, aye. Corbett, Correa.
Okay. We'll hold the roll open. Item number 2. Does that bill out?
Yes, it is. It does
Yeah.
have 7.
Okay.
Do you want to hold it open or?
Hold it open. We're going
Okay,
to wait for
okay.
Ms. Corbett.
Are we voting on 2?
Yes. The present vote now is 5-0. This is for SB 596, and it's due pass as amended. Anderson? Aye. Anderson, aye. Gaines? No, this is 596.
Keough.
Yes.
Yes. Gaines, aye. Corbett, Correa.
How many votes?
That measure has 7-0. We still want to leave that?
7 votes. We'll hold the roll open.
Okay.
Item number 3.
Item number 3, SB 599. The present vote is 4-2. No amendments, and this is going to do pass us to judiciary. Gaines?
Call the absent member.
Gaines, Corbett, Correa.
Call the absent members. This is on item number 3,
SB 599.
the Kehoe bill.
Kehoe bill. Gaines, Corbett, Corbett, aye. Correa. That's 5-2.
Call the absent member.
Gaines, Correa.
That has 5-2. Call the absent member.
Gaines,
On Keogh, no, please.
Gaines, no.
Gaines, no.
So that is, the measure has 5-3.
5-3. That measure is out. Do we know if Correa, Senator Correa, is coming?
He's not coming.
He's not coming. Okay. So we'll close the roll on that. Let's go back to item number 1.
Item number 1.
Call the absent member.
Okay. Item number 1, SB 220. The present vote is 7-6. Corbett? Aye. Corbett, aye. Correa. So that measure
That bill
has...
measure is out, has
Okay.
eight votes.
8-0.
8-0. We'll
That's
close.
a due pass to the Senate floor.
Okay. Item number 2.
Item number 2, SB 596. The present vote is 7-0, and this is due pass as amended. Corbett? Aye. Corbett, aye. And that measure has 8-0 now.
Okay, that measure is out, 8-0. We'll close the roll on that. We just did number 3.
Yes.
Item number 4. Calderon.
Item number 4, SB 615. The present vote is 8-0. Is due pass to health, and Correa is the only one.
Okay.
And that's
We'll close the roll on that. That bill is out, 8-0. Evans.
And item number...
That was no vote on item number 5.
Right.
Consent item number 6.
Consent item number 6.
Are we all up?
We're all out on that one.
Okay, that roll is closed on that.
8-0 on that
8-0. And item number 7.
SB 713, the present vote is 7-0, and this is a due pass to judiciary. And with
Call the roll.
Okay. Anderson? Aye. Anderson, aye. And Correa is not.
Okay. The roll is closed on that.
It is 8-0.
8-0. The bill is out. And last item, number 8. Number 8.
Number 8. Yes. SB 715. The present vote is 6-0. The motion is to do pass to judiciary. And calling the absent members: Anderson. Aye. Anderson, aye. Corbett. Aye. Corbett, aye. That measure has 8-0.
That bill is out. And that concludes the business for today's Insurance Committee. Thank you all for attending.